Donald Trump has issued a flood of executive orders during his second term, from freezing federal spending to revoking birthright citizenship. Those orders have triggered an unprecedented backlash from the judiciary. Dozens of federal judges across a handful of blue states have issued nationwide injunctions, effectively halting major policy moves with a single stroke. Critics, including Trump and congressional Republicans, decried this as judicial overreach, accusing activist courts of straying far from traditional limits and undermining executive power. Well, on Friday, we saw a monumental step forward for the integrity of our constitutional republic, a powerful rebuke to the creeping judicial overreach that has plagued our nation for far too long. The Supreme Court, in its wisdom, has delivered a decisive blow against what can only be described as the dangerous trend of the universal injunction. Now let's take a step back and remember how we got here. President Trump, acting on a clear mandate of the American people, issued Executive Order 14160. This order rightly and responsibly sought to clarify what it means to be subject to the jurisdiction of the United States for purposes of birthright citizenship. It targeted very specific circumstances. Individuals born in the U.S. whose mothers were unlawfully present or here on temporary visas, and whose fathers were not U.S. citizens or lawful permanent residents. It was a necessary move to protect the meaning and value of American citizenship, something that far too many in the progressive elite have tried to undermine. But what happened next? Well, predictably, the radical left, through activist groups like CASA and complicit states like New Jersey and Washington, immediately ran to their friendly district courts. And what did those lower courts do? They didn't just rule on the specific plaintiffs before them. Oh no. They issued universal injunctions, orders that effectively blocked the president's policy nationwide for everyone, not just the people who actually filed the lawsuit. Think about that for a second. One unelected judge in a single district with the stroke of a pen could halt a presidential policy for the entire country. This isn't how our system was designed. This isn't the separation of powers the founders envisioned. This is judicial supremacy run amok, a imperial judiciary, as Justice Barrett so eloquently put it today. It creates a scenario where a single judge can dictate national policy, overriding the executive branch and effectively the will of the people who elected the president. Now, the government didn't ask the Supreme Court to rule on the constitutionality of the executive order itself. They knew, and we know, that question will be resolved in due course. What they asked for was simple: for the courts to operate within their proper bounds, to stop usurping legislative and executive power. They asked for a return to common sense, to the rule of law, not the rule of activist judges. And Friday, the Supreme Court delivered in a clear 6-3 decision led by Justice Amy Coney Barrett. The court unequivocally stated that universal junctions likely exceed the equitable authority that Congress has given to federal courts. This is a massive victory for limited government and judicial restraint. The majority opinion laid out the truth plainly for all to see. Our federal court's power to issue equitable remedies comes from the Judiciary Act of 1789. And that power is strictly limited to what was traditionally accorded by courts of equity at our nation's founding. And guess what? There was no such thing as a universal injunction back then. It was non-existent for most of our history, only gaining popularity in the 20th and 21st centuries. As the decision said, it's a new potent remedy. The dissenting judges tried to claim some historical lineage, clinging to obscure bills of peace and taxpayer suits. But as the majority correctly pointed out, those are a far cry from today's universal injunctions. Bills of peace were precursors to class actions, which have strict procedural safeguards. Universal injunctions, on the other hand, are a dangerous shortcut that bypass those very protections, allowing de facto class actions at will without any of the due process that the rules of civil procedure require. This isn't flexibility and equity. This is outright judicial adventurism. The court also clarified the concept of complete relief. The lower courts claimed that they had to issue nationwide injunctions in order to give plaintiffs complete relief. But Justice Barrett rightly explained that complete relief is about providing full redress to the plaintiffs in the lawsuit, not to everyone similarly situated across the country. For example, a pregnant mother challenging the order gets complete relief if her child is not denied citizenship. Extending that to every other person in America doesn't make her relief any more complete. The government has a right to enforce its policies, and blocking them nationwide without proper cause is an improper intrusion on a co-equal branch of government. Even the dissent admits there are good reasons not to issue universal injunctions in the typical case. They concede these injunctions incentivize forum shopping and operate asymmetrically against the government, forcing the administration to win everywhere while the plaintiffs only need to win once. So even if they see the problems, why fight to preserve this flawed tool? The dissenters' voices, in particular Justice Jackson, decried this as an existential threat to the rule of law. She accused the majority of allowing the executive to violate the Constitution with respect to anyone who is not yet sued. This is pure hyperbole, ignoring the fundamental principle that our courts are not meant to be general oversight bodies for the executive. Their role is to resolve specific cases and controversies. The executive, like everybody else, is bound by law, but the judiciary has its own limits given by Congress. To claim otherwise is to advocate for an imperial judiciary, that one that can dictate policy without accountability. The brilliance of this decision is that it restores proper order. If parties want broad nationwide relief, they must use the proper, well-established mechanism, the class action lawsuit. This ensures due process, proper representation, and the rigorous analysis required for such sweeping remedies. It also allows for the necessary percolation of legal issues through different courts, fostering a healthy legal dialogue before a definitive nationwide ruling is reached. As Justice Kavanaugh noted, this will bring substantially more order and discipline to challenges against federal actions. This isn't a decision that lets the president ignore the law. It's a decision that tells judges to follow the law too. It ensures that policies are challenged and, if necessary, blocked through the proper constitutionally sound channels, not by the unilateral decree of a single judge. This is a return to balance, a victory for the rule of law, and a crucial step in preserving the delicate checks and balances that make our republic truly exceptional. Thanks for watching, guys. We go live Monday and Thursday on Rumble and X, not here on YouTube for obvious reasons. So go find us on the other channels. Hit follow. We appreciate it. Thanks.